she has vast experience dealing with labor laws. She has done certain projects related to ILO, and she is internationally known for her work on Indian labor law. And today she is going to speak on right to livelihood. Our constitution contains Article 39, Clause A, where state is obliged to provide adequate means to livelihood to everyone, to all citizens. And it has the decent work agenda currently promoted by the International Labour Organization. So today, Professor Kamala ma'am will speak on right to livelihood and its different dimensions. Welcome, ma'am, for sparing your valuable time for us. Thank you, ma'am. Now you can continue, ma'am.
Thank you. Thank you very much, Parveen. I thank you for that kind introduction. I also thank the professor in charge, Law Center 1, other colleagues at Law Center 1, Dr. Alok and Dr. Sukanya, apart from Dr. Sarabjit, for this invitation, and other colleagues for this invitation to speak here today. It's actually a real privilege for me to be part of this series of webinars being held on the occasion of the 50th anniversary of the founding of Law Center 1 Faculty of Law. And there's a special reason for me personally too. I started my career as a teacher with a brief stint at Law Center 1 when it was located in Mandir Marg a long time ago. This evening, I propose to speak on the Constitution and the right to livelihood. The present COVID-19 times and the crisis that it has thrown up in the world of work has placed the matter of the right to livelihood as one of the central challenges confronting India today. The returning migrant, walking back hundreds of thousands of kilometers, or waiting endlessly in the brutal Indian summer heat to catch a train or a bus to return home, has become the abiding image of the COVID pandemic, an image which is burnt onto our collective public memory. This crisis has also helped shift the question of work and workers center stage in public discourse after a very long time. Is there a right to livelihood in India? Should there be one? What duty does it cast upon the state, society, and employer? What is the future kind of society we intend to build? These are the questions that I am raising today, and some aspects of these questions lie at the root of various petitions that are currently pending before the Supreme Court, awaiting a hearing and the Supreme Court's judgment. Let me first turn to the right to livelihood as a human right. Am I audible, Parveen?
Yes, ma'am. Audible.
Okay. Yeah, okay, thanks. It's often stated that human rights are available to all persons by the sheer dint of their being human. What set of capacities or qualities constitute a human being has been a contested one, and this debate is well reflected in the literature. If you take the ideas of Immanuel Kant, the Kantian idea of will and choice that defines personhood in the barest possible manner is the way of indicating the formal equality of all persons in a modern democracy. This idea of formal equality of all persons is often counterpoised against the Marxist idea of a real person, a person with economic and social needs, and who alone, therefore, should be or can be the bearer of rights. Many years ago, our own Professor Upendra Bakshi, Professor Emeritus, University of Delhi, put forward the position that the necessary condition before a human being can enjoy human rights is that she has to first enjoy the right to be human. In other words, basic needs would have to be met before a person can exercise his or her human rights. And this approach is reflected in Article 25 of the Universal Declaration of Human Rights, which affirms, and I quote, "Everyone has a right to a standard of living adequate for the health and well-being of himself and his family, including food, clothing, housing, medical care, and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his control." The rights to subsistence has been termed as a basic right by other scholars also. The very well-known philosopher Henry Shue talked of basic rights, which would include the right to subsistence. Can this right to subsistence be a legal right? Can this human right to subsistence be a legal right? Can such socio-economic rights be validly recognized by a legal system? Political theorists from Morris Cranston onwards, and there are a large number of them who hold such a view, have refuted the label of rights being ascribed to such basic needs. The Universal Declaration of Human Rights in 1948, which was drafted almost contemporaneously with the Indian Constitution, saw human rights as an indivisible whole. The categorization of two sets of rights was to come much later, when the two international covenants were adopted in 1966 at the peak of the Cold War. The Cold War debates over human rights, in which the civil and political rights were characterized as relatively costless, that is, it did not cost anything to the state, when compared to the second generation of social, economic, and cultural rights, have now been shown by many scholars to be quite inaccurate, that this distinction is inaccurate, that there are costs attributable to both civil and political rights as well as social economic rights. For example, you have scholars like Mark Tushnet and others who have shown this in a very rigorous way, really. Despite this debunking, the moral basis of social rights continues to come periodically under challenge. For instance, the demands for increased allocation for social rights during times of economic crisis appear to underscore the point made by the critics that social rights are not legitimate claims, but are merely benefits that need to be granted to the needy, depending on the economic capacity of the states. That is, they are only welfare benefits and they are not rights. When we turn to India, I think it's important for us to note that the debate has taken a slightly different turn. We have not entirely mimicked that which has happened in other countries in the world. There was a remarkable consensus across the political spectrum that the yet to be drafted Indian Constitution, I'm talking about the 1930s and the 1940s, and there was a remarkable consensus across the political spectrum that the yet to be drafted Indian Constitution should have a comprehensive set of rights that would include not only the negative political liberties, but also the social rights that would be essential for the social transformation of the country. This was echoed and developed further in the Motilal Nehru report on a draft constitution that was set up in 1928. And this division, which corresponded between civil and political rights and which are immediately enforceable, and the economic, social, and cultural rights that are subject to gradual realization, found its way through the 1940s and became a part of our Indian Constitution when the Constituent Assembly was debating this. The Constituent Assembly debated the nature of the rights to be included in the new Constitution. And it's important for us as students of law to look back and see exactly where this shift occurred, this unified notion of rights getting split into two, and you can sort of locate it in the subcommittee on fundamental rights that was set up by the Constituent Assembly in 1947, which approved the division of rights into justiciable fundamental rights and directive principles of state policy. And the latter were to be guides to the government, but which were not to be cognizable in the courts of law. This was, of course, bitterly debated during the draft, but this was the eventual outcome that occurred in the crucial period of December to 1948 to January 1949. That's a very critical time for us. The eventual constitution as adopted carried forward this cleavage, with part 3 of the constitution envisaging the more classical civil liberties, while the positive social rights, socio-economic and other programmatic rights were consigned to part 4 of the constitution. As students of law in India will recognize the justiciability of legal rights in the sense of rights that can be enforced by the courts by upholding the right of the right holder through identifying and then subsequently enforcing the duty against the duty bearer. This has been gradually broadened by a broad interpretation afforded by the court, our Supreme Court, of our Constitution. And the chapter on fundamental rights has been interpreted keeping the directive principles of state policy in mind. Thus, the Supreme Court interpreted Article 21 and the right to life and declared that there is a right to livelihood in India and that it is part of the right to life. Speaking for a 5-judge bench in Olga Tellis versus Bombay Municipal Corporation in 1985, Chief Justice Chandrachud, this is of course the father Justice Chandrachud, of our present Justice Chandrachud, Chief Justice Chandrachud declared, and I quote, and it's an extensive quote, but I think it's so crucial I'd like to read it out. If the right to livelihood is not treated as a part of the constitutional right to life, the easiest way of depriving a person of his right to life would be to deprive him of his means to livelihood to the point of abrogation. Deprive a person of his right to livelihood and you shall have deprived him of his life. Indeed, that explains the massive migration of the rural population to big cities. They migrate because they have no means of livelihood in the villages. The motive force that which people have desert in their cause desertion, of their hearts and homes in the village and who struggle for survival, that is the struggle for life. So impeachable, and I'm still continuing the quotation, so unimpeachable is the evidence of the nexus between life and the means to livelihood. They have to eat to live. Only a handful can afford the luxury of living to eat. That they can do, namely eat, only if they have the means to livelihood. That is the context in which it was said by Justice Douglas that the right to work is the most precious liberty because it sustains and enables a man to live, and the right to life is a precious freedom. End quote. For arriving at this interpretation, the Supreme Court relied on various directive principles of state policy. Article 39A, as Dr. Parveen has just mentioned in his introductory remarks, which provides that the state shall, in particular, direct its policy towards securing that the citizens, men and women equally, have the right to an adequate means of livelihood. Article 41, which is another directive principle, provides that the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work in case of unemployment and of undeserved want. And Article 37, of course, provides that these directive principles, though not enforceable by any court, are nevertheless fundamental in the governance of the country. Now, what I would like to do for the remaining part of today's talk is to look what kind of correlative duties are then laid upon the state. There is this declaration, but what really is the duty? And upon whom does this duty lie? Notwithstanding understanding the fact of this general ratio, which is there in these ringing terms in the Olga Tellis judgment, that the right to life includes the right to livelihood, the Supreme Court was very conscious and very cautious about the corresponding duty that it entailed upon the state. The Supreme Court was extremely cautious about what it was laying down. And it was cautious to lay down whether the state was obliged to provide such livelihood or not. And it stated, and I quote this because it's a very important quotation, because you now can see the way in which the right and the duty are running somewhat asymmetrically. The state may not, by affirmative action, be compellable to provide adequate means of livelihood or work to its citizens. But any person who is deprived of his right to livelihood, except according to just and fair procedure established by law, can challenge the deprivation as offending the right to life conferred by Article 21. End quote. In other words, the right is actually a right not to be deprived of livelihood, but is not a positive right to be given livelihood. And therefore, this important part of the Olga Tellis judgment is something that we must bear in mind about the nature and the limited nature of the duty which is cast upon the state. Not to deprive somebody who has already got a livelihood, but not a positive duty to give one. Yet, as I argue later in the course of this talk, this duty cast upon the state has broadened in later years, and it includes the duty to provide work in certain circumstances, as well as the duty to provide a modicum of social assistance when such work is not available. And so I basically argue that the limitation which is there in Olga Tellis has loosened somewhat by the course of development of the last 40 odd years, and we must keep it in mind when we are looking at the right to livelihood. Let us examine this matter a little more closely. As I have written at length about this elsewhere, the right to work is one of the primary ways of ensuring a decent livelihood for a significant proportion of the labor force today. The right to work, seen as a claim against the state or the employer to obtain employment, was of course never operationalized in countries outside the socialist bloc, except in the form of public works during famines and other emergencies. So if you were a comparative constitutional law scholar, you would see that it was really in the socialist or semi-socialist constitution that this right to work really was operationalized. The right to work has also been interpreted to include its negative aspect of freedom from certain forms of work, and the freedom from forced labor is the most well-known manifestation of the negative quality of the right to work. This understanding of the negative nature of the right to work is itself a gendered notion also, since it is usually restricted to paid work performed under coercion or customary practices, whereas the unpaid labor performed by women within the household because of compulsion by patriarchal or by religious authority is not acknowledged as a form of forced labor at all. So the negative aspects of the right to work that I just now mentioned have their gendered aspect to it as well, and it basically excludes the unpaid forms of work that women do carry out. Thus, the right to work, coupled with the need to treat a person with dignity, is another facet of Article 21 and the right to life. That is, if the right to life includes the right to livelihood, it also includes the right of a person to be treated with dignity and requires that the minimum conditions of decent work are available to all those in employment. That the right to life entails the right to livelihood, and where this takes the form of waged employment, that is employment for wages, decent work conditions in terms of minimum wages and decent working conditions and other minimum rights are to be met by the employer. So you see a slow shifting from the state-centric notion of the right to life in Article 21 to its horizontal effects to the employer also. And this is the first shift that we notice in the broadening of Article 21 that you see. And therefore, it comes as no surprise that there is a huge body of scholarship that declares that labor rights are human rights. And whereas human rights have traditionally been state-centric, most labor rights are against the employer, but they are seen as part and parcel of human rights. And in the Indian case, the shifting happens because we couple livelihood with dignity, and that entails that the employer is duty bound to provide a minimum modicum of standards. Yet we must bear in mind that for the 450 million persons in India's labor force, regular employment or casual employment is not the norm. According to the latest periodic labor force survey, which was released last year, this is an annual document. If you look at the 2019 document, which is the latest that we have in India, it shows us that during 2017 to 18, about 52% of rural households had their major source of income from self-employment, not salaried or waged employment, 52%. And the share of households, rural households, whose income came from casual labor was 25%, and those with regular wages or salary was a paltry 12%. In urban areas, the numbers change very slightly. Self-employment is again is about 32%. The share of household with regular wage or salary is about 41%, and those with casual wage or salary, casual employment, is 11%. I beg your pardon. A more proactive, and what conclusions can we draw from this? A more proactive understanding of the right to earn one's livelihood is therefore needed for those people whose lives are precarious because they lack regular waged employment. Those in the informal economy are often in this position and are often the victim of policies that dispossess them of lands, receiving only a small compensation, or due to the lack of necessary skills and education, because they have been priced out literally out of the educational market, or because they are victims of social discrimination or ill health or disability or old age. It does not permit them to earn a living either through waged employment or through self-employment. A broader idea of the right to work as encompassing the right to pursue one's livelihood is necessary if we want to take on board the category of people who are self-employed. And you need yet another broader notion of the right to livelihood to include those who are unable to obtain waged employment or even self-employment. And it needs a broadening to include the right to obtain state largesse in the form of subsidies, maybe to set up one's own business, to access loans and facilities, and the enhancement of one's capabilities to achieve at least self-employment. But all these questions has rarely been the subject of rights talk. Many people are in this unenviable and vulnerable position of unable to obtain employment or even obtain livelihood because they are in these circumstances precisely because of decisions taken by the state at the level of policy, which causes impoverishment, or they are vulnerable because of an unequal, what Rawls would have called an unequal original position. The way they came into this world was itself unequal. It is because of the power, it is because the state has the power to make economic and social decisions that can impinge on the right of so many persons and whose destiny is shaped by decisions in which they have no voice. That is the reason, because the power lies with the state. It is for this reason that it is upon the state to once again provide for social assistance for those who have undeserved want, which is captured so well in Article 41 of our Constitution, which provides that the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work in the case of unemployment and of providing public assistance in the case of undeserved want. So what I have argued so far is that there is a right to livelihood. That, coupled with the right to dignity, gives us the right to have decent conditions of work. Also, that because waged employment is only covering about 50% of Indian workforce, there is a right to get livelihood, which means that the state has to provide those necessary impetus, subsidies, loans, etc. to obtain this and rights. And lastly, if for various reasons of social discrimination or other causes of vulnerability, you are unable to obtain either work or livelihood, there is a duty cast upon the state, and the source of the duty lies in the power of the state to determine the manner in which society goes forward, which thereby decides the fate of millions of people in India. That is to say, on the one hand, the duty cast upon the state to provide for livelihoods could take the form of ensuring some modicum of employment in times of crisis. Many of us have heard of the terrible famines that took place in colonial times. The Great Bengal Famine, as captured by Amartya Sen in his book Poverty and Famine, was a socially constructed famine. It was not a natural debacle. It was socially constructed that people had to pay a price. And therefore, schemes like the Manrega, Rural Employment Guarantee Act, and the much earlier Employment Guarantee Scheme developed in Maharashtra in 1960 to deal with the terrible drought which occurred there in the 1960s, goes one further, and it creates a statutory right in persons to obtain work in rural areas in order to offset hunger and vulnerability. This right-centric approach is distinct from one that relied on food provided by either government or well-meaning persons as an ex gratia or an ad hoc measure. The people who have queued up for food are not beggars. They have been working people who have been denied their rights. And schemes such as Manrega move from a mere welfare benefit to one which is based on statutory right. Thirdly, let me now move to the right to social assistance or social security. Increasingly, the world is moving towards a recognition that social security and social assistance is also a basic human right, and it's not merely something of welfare. Social security is a human right which addresses the need for protection against certain contingencies and life risks and meets certain social needs. A system of social solidarity towards the well-being of others not so fortunate is born of the understanding that each individual is part of an undivided whole. No individual can hope to rise beyond a certain level unless other fellow human beings also prosper. And this learning has come to us in a very stark manner and very tellingly in these COVID times. You could be a middle class or a rich person having your own electric generator, and you couldn't be bothered about whether the electricity is being generated by the state or not. You could have your own water system, your own enclosure, your own enclosed colony within which you live, and you could exclude the other. But the air and the virus understands no man-made walls and distinctions between rich and poor. And therefore, a system of social security for those who are unable to get unemployment or those who are unable to obtain their own livelihood is required in order for each person to obtain a minimum of subsistence. I go back to the question of whether there is a right to subsistence. Is it a human right? And is it a legal right or not? And I think it's very clear that it is. The reason is the social solidarity which binds all of us. None of us can secede from fellow human beings and have it go on in a very long way. I think COVID has shown us that it cannot happen. Even countries that are vocal supporters of free market and free enterprise, such as the developed countries in the West, have unemployment insurance, which is nothing but a recognition that state and society owes those who are unable to obtain work or those who cannot work due to old age, disability, or because of childhood, the minimum amount required to make a decent life and to keep body and soul together. As indicated by the ILO, these social security systems guarantee income security and health protection, the prevention and reduction of poverty and inequality, and the promotion of social inclusion and human dignity. It is for this reason that the International Labour Conference adopted a new standard in 2012, the Social Protection Floors Recommendation of 2002. That is, you have a social floor, which is the minimum of social security that everybody must get, because there is this basic right to subsistence. And of course, at the top, you have your wages, which is determined by your earning capacity and other things. But between you, no person should be allowed to fall below this. This approach of a minimum of social protection as a third facet of the right to livelihood is a foundation which is recognized by India and in our constitution by our Supreme Court. The Supreme Court in CESE Limited versus Subhash Chandra Bose, a decision of 1991, held that our constitution, its preamble, and particularly part 4, reinforce that socio-economic justice is the bedrock of an egalitarian social order, and that the right to social and economic justice is a fundamental right which is part of Article 21. Let me now draw together all the points that I have raised in today's talk and move towards my conclusion. I suggest that the right to livelihood, which is now being recognized as part of Article 21, goes beyond merely protecting a person from being deprived of his livelihood or her livelihood. But in fact, it has moved forward in 3 very important ways. One, those who are employed need conditions that ensure a basic minimum of decent working conditions. Therefore, any proposal that makes the entire body of labor law and minimum conditions from the world of work vanish, as some have advocated in recent times, these new proposals that are there, would go against the right to life and dignity and livelihood embedded in our constitution. Because you need these minimum conditions if the right to work, if the right to livelihood and the right to dignity are seen as part and parcel of the right to life. In fact, I go so further and state that any state assistance which is provided to industry or the MSME sector, for example, we have heard about the huge grants that are now. Finance Minister unveiled this over 5 press conferences earlier last month, that any state assistance to industry or a relief package to industry must be predicated on and made conditional that the basic laws such as minimum wages, safety norms in factory, non-discrimination, etc., are fulfilled by these industries vis-a-vis their workers. And it's only upon this condition being fulfilled should they be entitled to these relief measures. That's one aspect of 21 and the way in which the right to livelihood develops. Second, I suggest that the ability of those who seek to find their own ways of livelihood, that is, those who are not relying on waged employment, gets impacted in many ways by the economic and fiscal policies that reduce their ability to claim state resources or reduce their access to markets or increase impoverishment and inequality. That the state's policy in very many vital ways determines whether people can have their livelihoods or not. Policy impacts this in very many ways. Since the state has the right to create these policies that variously impact individuals and sometimes impoverish them, that is, people who are not poor now become poor. That's the process of impoverishment. There is a duty cast upon the state to provide meaningful employment to those who require it. While the Manrega is, of course, located in a statute, I argue that the duty to provide employment is in fact located in Article 21 itself, because the process of seeking their livelihood is imperiled in many ways by the state's policies which push people into impoverishment and vulnerability. And therefore, there is not only a duty to provide such, and we can see this recent 40,000 crores which has been provided for Manrega, and the necessity to provide necessary support for those who are self-employed. For example, the new grant that has come into place for street vendors and several other things. Third, for those who are unable to obtain either waged employment or self-employment or this distress employment that I just discussed in the two limbs earlier, such as farmers, street vendors, small artisans. And for those who are unable to obtain their own livelihood or get waged employment, which will ensure at least a minimum threshold, there is a need to recognize that such persons have the right to social security in the form of unemployment allowance. And they also have a widespread universal right to access public health, clean drinking water, and clean living conditions. And these rights, the right to unemployment allowance and the right to broad public health, drinking water, and living conditions, is not contingent on their being a worker, but actually as a person living in India. These three broad ways of the rights of decent work in employment, the right to have government policies that encourage self-employment, and a duty to provide employment if people are impoverished, and the right to unemployment allowance. These three aspects of the right to livelihood, I conclude by saying that in these times, the right to livelihood goes far beyond and translates as an economic right to obtain gainful employment with decent working conditions or a minimum of livelihood with a safety net provided by Social Security in the form of income security and health benefits. This conception has to be at the center of the imagination of any legal framework that we develop in these COVID and in future post-COVID times. Thank you.
Ma'am, there are certain questions from some of the viewers. One viewer has asked that there is imbalance between right to life and right to livelihood in respect to case of migrant laborers during this pandemic situation. So which right should be given superiority, priority? Because of life is protected, then right to livelihood is bound to be jeopardized.
You know, as has been said by many people elsewhere, it's a false, it's really a false dichotomy. Because if a person has to live, he or she requires basic subsistence rights. And either those subsistence rights come from providing livelihood in the form of work, or if the state is unable to do that, through public assistance or unemployment benefit. Because I don't think that we should look at it as either or. As I have argued just now, merely because food has been provided to people. In fact, if you've been following court cases, it was argued in one of the court cases, of course, the final decision is still eagerly awaited. But in the course of the argument, some of the lawyers argued, why should we pay wages to workers? Because we are anyway, they can go and get food. Food is being provided. And you know that minimum wages is much beyond food. You need livelihood, or in its absence, you do need assistance. And the right to livelihood is very much a part and parcel of a right to life. I don't think any purpose is served by separating the two and then setting up a false dichotomy between the two of them.
One question is regarding NAREGA. Those who are employed under NAREGA, some states do not pay minimum wages. Can you just throw some light on it?
So this has, of course, been a question, and I've actually written about it also.
Yes, yes.
And the thing is that one of the problems with the Manrega Act is that it says that the state government will declare the wages. I understand it's currently 180 or 200 rupees, which may be lower than the minimum wage. We, of course, still don't know what is going to be the national floor level minimum wage. But be that as it may,
189, ma'am. Rupees 189.
That dichotomy is there, and there is 180. Okay, I stand corrected. Okay, now that may not be the minimum wage in some states, yes, yet it is being paid under Manrega. And we are yet to come to a definitive view on this point from the Supreme Court. So till that happens, we have had high courts that have said differential things, and we are still bound to, because the Act as it stands gives the right to state governments to determine the Manrega wage. And I have to share with you that even the new Code on Wages 2019, which has been adopted, doesn't overrule this on this particular point. So I think we are going to be seeing for some time to come a divergence between a state minimum wage and the Manrega wage. But the important thing is that in these crisis-ridden times that you are getting at least the Manrega wage.
Parliament enacted in 2013 this Prohibition of Employment as Manual Scavenger and the Rehabilitation Act, and court upheld it. Court did not rely on dignity, rather court more focused on, yes, safety equipment should be provided. So what is your opinion? Because it leads to position which is constitutionally not so much sustainable.
I think the Supreme Court judgment says many things and many good things, because it points out that there is this Prohibition of Manual Scavenging Act. It has laid down very, very important guidelines. Those of us who've studied it know that. And the need to provide various equipment at the time, and also a direction to the state. You know that every state government had to file an affidavit about the identification and prohibition of manual scavenging, and the need to, and I think the Swachh Bharat Abhiyan has also contributed a great deal, because it has done away with these the manual scavenging in several states. So I think that, the case, of course, arose from Article 17, but the judgment does make the link between 14, 17, and 21. So I think that the reading of dignity, and I think it underscores the point that I was making earlier, that every form of work is not necessarily falling within the ambit of livelihood. Exploitative work which is inhumane. For example, 23 and 24, Articles 23 and 24 also get read into Article 21. So that would be the way in which I read even that very important judgment.
Niharika has asked one question, ma'am.
Yes.
What would be the relief for people who have not been paid their wages for the period of the lockdown, despite the government asking the employers to do so? Can the right to livelihood with dignity be made strictly justiciable, where either the employer or government is ordered by the court to pay the wages?
Look, let me say two things here. I think as a society, we must make unemployment
Yeah.
allowance as a duty cast upon the state. Most countries in the world have unemployment allowance, which is made by the state out of its budgetary allocations. Okay? Now, in this particular case, of course, the government passed the order that employers, for those 2 months, after that, I think May onwards, it has been withdrawn. Okay, but in March and April, definitely the duty was on the employer. So that arising from that notification, the legal basis has been against the employer. But I think the occasion of the COVID brings home to us that India as a society cannot move forward unless we have an unemployment allowance. Please remember that the Manrega Act also has a form of unemployment allowance. Everybody, as of right, is entitled to 100 days waged work. If a job card is given and such right is not made available, the Manrega Act talks of an unemployment allowance. The fact that in practice it has not been operationalized is a different matter. But in response to Niharika's question, Niharika, thank you for this question. I would say that for those 2 months, of course, the employers, because of the government notification, but it begs a far bigger question. What happens if the industry is unable to operate because of a financial crisis? The law is very clear that if you're unable to pay minimum wages, then you should not exist. Maybe you will close down. But then what happens to the worker? Which is why the right to, we must push forward in terms of law reform to have a meaningful right to social security, which is not just health insurance, which is not just old age insurance, but also is unemployment allowance.
Divakar has asked me this question that many states, in the wake of COVID-19, many states are trying, and we know that some have relaxed labor laws to a great extent to just to attract more investment. So, how do you think it can impact right to livelihood? We know that labor laws provide floor of rights. So, will floor of rights when state is taking away whatever rights you have?
You know, if you just go back to one of my concluding points, I did make the point that the right to livelihood is coupled with the right to dignity. And if you work, you need to have decent conditions. And therefore, to say that labor laws will not apply, that you will have a, it's a very slippery slope because you will keep going down, but then you will have to do away with dignity. And therefore, please also note that in fact, those proposals have also been shelved, and correctly so and wisely so, because you cannot have a path of development where those who work do not get their minimum rights. This goes against Article 21. It also goes against the entire body of case law which is developed in India, that if you work, you need to have decent working conditions. Otherwise, what is the meaning of Article 23 and the right against exploitation? It just goes out of the window.
In India, most of the labor laws, they provide lot of protection, but their coverage is very less. For example, the formal sector is just covers 8% or less than 8% of the total working population. So how to include more and more people? So it's a
yeah. Can I link it to a question that I see here from
yes,
which says about, do you think sending the migrant workers back to their hometown would result in them not returning after lockdown and finding a local job instead? So there are moves that, we must have some sons of the soil and have local people. But the point is that at least 10% on many of these industries are migrant workers. So if you take many of the states in India, there is a lot of internal migration that happens. I think the signal that is coming here is that decent working conditions must become necessary because it's useful to get back the migrant workers. And I think the Home Minister and in fact the MSME, the Minister in charge of MSc, I saw the interviews and they both made this point that there is a need to provide conducive conditions in order to get the migrant workers back. Because once industries restart, we do need those workers. And we also need to learn some lessons. That is that there must be certain decent working conditions because experienced workers are also hard to come by. Now, if local workers are going to replace, well, that's fine. But then the workers who've gone back to their hometowns will have to demand and get either Manrega jobs or the unemployment allowance. Any way you look at the situation, unless India as a society is willing to acknowledge that the right to livelihood includes the right to decent work, includes the right to get jobs for immediate crisis like Manrega, and includes the right to unemployment allowance, we are going to be staring at a far greater social crisis than I think that we have the capacity to deal with. And therefore, this development of Article 21 and the right to livelihood, and I hope that when the Supreme Court is hearing these matters and we are awaiting their decisions, there are large numbers pending, that they will delineate the right to livelihood and Article 21 in these further ways in which I suggest.
Well, your opinion on this legislation, there is street vendors, protection of livelihood and regulation of street vendors Act 2014, particularly in this time, because they were not allowed to do their business because of this crisis.
That's true. That's true. You know, many people who do self-employment do it not to earn a huge amount of money. It is actually subsistence earning. So in India, we have a very peculiar situation that people work very hard, but still they are poor. So you have this, what I can call in English as an oxymoron, that you have working poor. You work from morning to night and still you don't even earn a decent amount. Now, oftentimes for a migrant who comes to an urban area in search of livelihood, you remember that wonderful paragraph that I read out in the Olga Tellis judgment, that they come to thinking, and Justice Chandrachud, Chief Justice Chandrachud, I must clarify, talked about migrants coming for work. Now, when they come for work, and they come, and often the easiest is to put up a table and somebody making very, very marginal profit, bearing all the risks. If they have fruits or vegetables or clothes or whatever gets stolen or lost, etc., because they don't even have capacity. Now, the 2014 Act is a very important act because it's a result of a large campaign by street vendors all over India. And there are millions of street vendors. By the last count of the NSS survey, there could be upwards of 5 million street vendors across India. And this is an important section of our working population. So, I was noting down, for example, that when Finance Minister mentioned a 5,000 crore special credit facility, which she said would be made available to the 5 million odd street vendors. Because these are people who take very, very micro loans. Loans as small as 5,000 and 10,000 rupees as running capital for moving things on their cart. Okay, those of us who earn salaries and are comfortably off, like teachers like me and you, I mean, 5,000 rupees is a small sum, but it's a big amount for 5 million people. And therefore, your question was on the Street Vendors Act. How do we provide livelihood? And the livelihood is provided by self-employed. And for the period of 2 months, when you don't work, you're reduced actually to a beggar status, right? and there are no savings to fall back on. The thela may have got destroyed, because what do these people do? They tie it up and leave it on a roadside. God knows what happened to it. Okay? And you may not have gone there to see it. After all, the lockdown happened within a few hours, and therefore the need for this initial seed capital. And I want to link this to the other point that, for example, MSME, okay, and I've been following the 20,000 lakh in rather great detail, the package, and for MSMEs, etc. The point that I'd like to make is that, and I think it's important, that the suggestion that any industry that gets it and which employs workers must then see to it that the minimum conditions of whatever sort are met. That it's not just money that goes without a further monitoring.
And we are now ending our session, and it was a treat to listen you. And we want to thank you on behalf of Law Center 1, on behalf of our professor in charge, and Sukanya and Alok, ma'am. Thank you very much, ma'am.
And thank you. And once again, greetings to Law Center 1, which is, of course, one of our own institutions in Faculty of Law.
Thank you, ma'am.
For the wonderful Golden Jubilee. And I thank you. I thank Professor Sarvjit and Dr. Alok and Sukanya and other colleagues in LC1 for this kind invitation.
Thank you so much, ma'am.
Thank you, ma'am.
Thank you.
Bye.